Hi, welcome to today's presentation on IP issues in advertising and media. I'm James Griffith, Ziliak Law. To begin with, I'd like to thank 2112 and the Center for Creative Entrepreneurship for hosting today's event. By way of introduction, I'm with Ziliak Law. We have a service concentration in entertainment, media, trademark, copyright, financing, and litigation. Our clients range from individuals to Fortune 100 companies. I have personally decades of experience protecting brands and creative content, and I'm happy to provide you with an introduction today to how those issues intersect with advertising and online media. The topics we're going to cover today include an overview of trademark basics, copyright basics, how fair use applies to both trademark and copyright, what the rules are concerning the use of another person's identity in advertising and media, and practical considerations to avoid common traps in putting together your website and your advertising. To start with, we're going to go over some trademark basics. Why trademarks? Well, trademark use online is important both from the perspective of your own mark and to make sure that you don't run afoul of the trademark rights of others. When you're putting together your own advertising and your own media, you need to be sure that if you're going to use the trademark of another, that you don't do so in an infringing manner. Similarly, if you're reviewing the media content or advertising of a competitor or someone on the internet, you need to know what the rules are to see if your trademark rights are being violated. So first, what is a trademark? Clearly, a trademark can be a brand name or a product name. It can be the business name. It can be your logo. Essentially, a trademark is anything that's used to identify and distinguish the goods and services of your company from those of another. And that can include things like product packaging, decor, and even sensory marks. Now, all of these types of marks are going to have different rules as to how they're protected and the scope of protection that they're allowed. And for more details on all of these issues with trademarks, I'd refer you to my earlier talk, Trademark 101, a guide to trademarks for non-lawyers. But we'll provide kind of an overarching guideline here that will be an abbreviated version of that earlier presentation. So how is it that you go about acquiring trademark rights? In the United States, use is paramount. In other countries like China and the EU, those are first to file jurisdictions. So priority in a trademark is governed by whoever files first with the trademark office. That's not necessarily so here in the United States. Here, whoever uses the mark first gets the rights first. Now, there are a few exceptions to that. If you file an intent to use application with the US Trademark Office, your rights can date back to that original filing date if you ultimately succeed with your application and begin using it. But simply filing the intent to use application doesn't actually get you trademark rights. You need to go through the process of proving use and ultimately obtaining a registration in order to have anything to enforce. Additionally, in the United States, you don't even need to file a trademark application in order to have trademark rights. All states allow for common law trademark protection simply by virtue of using a mark. Those rights can be limited geographically, and so the scope of those rights is going to be narrower compared to what is obtained with a federal registration. But as I said, use is paramount in the US, so even without a registration, you do have rights with respect to the goods and services that you're using the mark on in the local geographic area where you're using the mark, even without a registration. So common law marks are not governed by statute, but are granted protection based on their priority of use. So what that means is you could have several different parties using the exact same mark on the exact same goods and services, but if they're confined to different states or different geographic regions, they're not necessarily infringing on one another's rights. So, for example, if you have a small local restaurant that is operating in San Francisco and another in Austin and another in Poughkeepsie, New York, and none of them have any national advertising presence, there's no likelihood of confusion because none of their rights extend into one another's markets. So they all have trademark rights, but all of those rights are local to their particular businesses. Registered marks are granted federal protection, and so that grants a nationwide priority over all others as of the priority date given to the application. And that priority date can either be the date of filing, if it's an intent to use application, or it can be the date on which the mark was first used. In terms of choosing a protectable mark, what you're thinking about here is, with respect to the internet and advertising, are really the same sorts of things that you think about in protecting a brand in any other space. You will, have either a marketing department or the founder of the business, or even a brand consultant come up with a trademark that is going to be attached to the particular goods and services of the company. It can be referring to a product that's offered by the company, or it can be referring to the company itself. In choosing a mark, there are different levels of distinctiveness that a mark can have, and what the law considers here is the level of kind of uniqueness that the trademark conveys to consumers. How distinctive is it compared to other marks in the marketplace? And for this purpose, the law kind of categorizes marks, on a spectrum. The least protectable sort of name, it's not even a mark, is a generic word. And a generic word is just the name for a type of product, and it can't function as a trademark. The most protectable kinds of marks are either arbitrary marks or fanciful marks. And those are either made up words in the case of an arbitrary mark, or in terms of a fanciful mark, or an arbitrary mark is an English word or a word from a different language that's applied to a product that it really is unrelated to. So, for example, Apple for computers is arbitrary because there's nothing related to an Apple that has to do with Apple's products. So as applied to computers and all of the related accessories, Apple is considered arbitrary. You also have suggestive marks, which tell you something about a product, but which require a leap of imagination in order to kind of figure out what the relationship is between the mark and the underlying product or service. And you have descriptive marks, which require some work in order to achieve protectability. If you use a descriptive word for a product, you're basically telling the consumer something about the product or what it is through the mark. And that kind of mark is only protectable if the mark owner can show that consumers have come to identify that mark over time with the producer and its product. Because descriptive marks are not protectable through the registration process right out of the gate, there's often a battle with the trademark office over whether a mark is properly categorized as suggestive or descriptive. So, here are kind of, on the slide behind me, you can see that, in order to be eligible for protection, a descriptive mark has to achieve secondary meaning. And, that happens over time through advertising, through, the length of time that a product has been in use in the marketplace. And once a descriptive mark acquires distinctiveness, it can then be protected as any other mark. So if you're considering using a trademark, there's a certain process that any trademark attorney would recommend prior to beginning use. Basically, and putting in a little effort and investment up front can save a great deal of time and money later on in the event there's someone else out there already using the mark that you didn't know about. So prior to using the mark, a trademark lawyer is going to recommend that you do a search of the U.S. Patent and Trademark Office website, as well as do internet searches to see what businesses are out there who are using a mark that is either identical or confusingly similar to the mark that you're considering adopting. If you're going to have kind of a large-scale rollout, if a mark is going to be important to your business, if you're going to be filing a trademark application, we often recommend obtaining a full trademark search report that will both kind of give a detailed analysis of what is on the U.S. Trademark Registry, as well as provide a full picture of other common law uses that are out there that wouldn't necessarily be picked up by a search of the registry, as well as looking at internet domain names that are registered that contain the proposed mark in them, or a variation of them. There's a very detailed analysis that kind of goes into this in order to provide a risk assessment of who else is out there that could potentially object to the adoption of a particular mark. And then the person doing the search will conclude that either the mark is available or it's not available, or what often happens is it's kind of a gray area where there are potential risks that are out there in the marketplace, and it really takes an assessment of how significant those risks are in order to make a decision as to whether to proceed with the mark. In addition to kind of looking at prior use and trademark availability, the search can also shed light on how a particular mark might be viewed by the trademark office in terms of distinctiveness. So for example, if it rides the line between that suggestive and descriptive category we talked about earlier, a trademark search can give an assessment as to how a trademark examiner is likely to assess the distinctiveness by looking at similar marks and how those marks have been treated. So this is the ultimate test of determining whether a trademark is available based on the existence of other marks. And it's also the test that one would use if thinking about, whether kind of the use of another's trademark on your website is going to cause problems. It's the test that you use when considering whether someone else's use of your mark on their website or in their advertisement is causing a problem. It's really the crux of all trademark infringement litigation. The ultimate question in trademark infringement litigation is, first, does the plaintiff own a trademark? And if it does, is the defendant's conduct likely to cause confusion among consumers. And that's an overarching inquiry that requires a court to look at a whole variety of factors. The most important of those factors is going to be the similarity of the marks. If the marks themselves are not similar, under most circumstances, it's a no-go right from the start. If they are similar, then the next most important factor is going to be the relatedness of the products. Trademark rights don't exist in the abstract. No one owns the right to a mark on all products. Instead, trademark rights are attached to particular goods and services that are sold under the products by the product owner. Now, there's an exception to that under the trademark dilution doctrine, where particularly famous marks can be granted very broad protection, even beyond the goods and services offered by the mark owner. But those are limited to genuinely famous household names. So even if someone were to offer Microsoft hair salon services, Microsoft is such a famous mark known by everyone that they could likely prevent even totally unrelated services from being offered under that mark. But generally speaking, when you're talking about a trademark infringement action as opposed to a dilution action, the relatedness of the products are going to be a key factor. In addition to those two key elements, the similarity of the marks and the similarity of the goods and services, courts will also look at the degree of consumer care that's being applied, how similar the channels of trade are that the goods and services flow through. Is a consumer likely to encounter these products in a similar marketplace and similar stores? Do they appear at the same trade conventions? Is there actual confusion in the marketplace? Are consumers writing letters to one mark owner that are intended for someone else? That can be pretty powerful evidence that there's not only a likelihood of confusion, but that there's actual confusion in the marketplace. Sometimes, an infringer will evidence an intent to infringe a mark. Sometimes in piracy cases, not only is a similar mark being used on similar products, but that's the whole point. The infringer is seeking to trade off of the goodwill of someone else's mark. So all of these are factors that would play into an analysis of whether someone else's use of your mark on the internet or in advertising is infringing your trademark rights. It's a very similar analysis to what you would consider if it were a garden variety trademark infringement case with two products on a shelf. If they're being sold on the internet or advertised on the internet, it's just that analysis goes online. So there are different remedies that are attached to a trademark infringement action. If you become aware that your products are being offered in online marketplaces, under an infringing mark, or if your mark is being misused on social media sites, if counterfeit products are being sold or marketed through social media, then you have remedies through those sites themselves. All of the major social media sites and online marketplaces have takedown procedures through which complaints by a mark holder can be filed. It should be noted that this is one of the areas where having a trademark registration can be very helpful. Having to assert, simply common law trademark rights through this process can work, but it's far more persuasive and effective if you can point to a US registration as the basis for your takedown efforts. In addition to going to those sites themselves in order to seek a takedown, if the infringer has a website of its own, and your efforts to contact them and have the infringement taken down don't succeed, sometimes you can go to the internet service provider who supports the underlying website, and if you can provide them evidence of the infringement taking place on the website, you can sometimes get relief through a takedown of the website itself. This can be, something of a whack-a-mole kind of game where the website will just pop up on another ISP, and you're at it again a few weeks or months later with probably the same wrongdoers. But it does disrupt their operations, and potentially could lead them to seeking easier targets down the road. If your mark is being used in the domain name of a third party, and that domain name was registered in bad faith, there are procedures through which you can seek recovery of that domain name, either through arbitration or through a federal court action. If you end up needing to file an infringement action in court based on the misuse of your trademarks, one of the primary goals of such an action is typically to seek an injunction. An injunction is essentially a court order that will order the infringing party to stop what they're doing that's in violation of the law. Oftentimes that means an order preventing them from using the infringing mark, turning over or destroying any existing infringing goods, and that's in addition to the potential monetary penalties. In a trademark infringement action, the plaintiff can seek an award of the defendant's profits that are attributable to the infringing conduct, as well as any damages sustained by the owner of the trademark. Additionally, if the plaintiff has a registered mark, it can seek the costs of an action, up to 3 times the damages and its attorney's fees if the defendant's conduct was found to be willful. A few words on proper use of a mark, and this is particularly important with respect to use of a trademark in advertising and in copy that appears on a company's website. Generally, a trademark should always be used as an adjective. Oftentimes you'll see marks colloquially used as nouns, or in the case of Google, even a verb. But proper trademark use is going to be in the adjective form, in front of whatever noun refers to the underlying product. So when you're on your about page on your website and preparing that and talking about your products, it's often a good idea to do a review of your copy to make sure that you're following kind of this foundational trademark rule. If you don't, you run the risk of the public coming to see your mark not as a trademark, but rather as the type of good or service that's being provided. And that would fall into the generic category. And over time, some marks have become generic as a consequence of that change in consumer perception. So the next area we're going to talk about is copyright. We'll return to trademark in a little bit, but I wanted to talk about copyright because most of the content on a website, in advertising, is covered by copyright. Copyright's a form of protection granted by the Constitution to cover creative works. It gives the author a monopoly on his or her creations for a limited period of time in order to provide an incentive to create. A copyright comes about automatically as soon as an author puts his or her work into a fixed medium of expression. So that means as soon as you hit the save button on your computer, as soon as you write something down, it's actually subject to copyright protection as soon as that happens. But there are very significant benefits to registering copyright in works that have value. You can't actually sue for copyright infringement until you have a copyright registration in hand. Additionally, by having that registration before an infringement occurs, it gives you the ability to recover attorney's fees, as well as to pursue statutory damages. So in order to qualify for copyright, there are really two simple requirements. A work needs to be original to the author. In other words, it can't have been copied. And second, the work needs to possess a minimal degree of creativity. That level of creativity is not zero, but it's not very high either. Generally speaking, copyright is going to adhere to the vast majority of creative works. It won't protect things like common phrases, whether textual or musical. It's not going to protect titles, but generally speaking, it's going to protect the vast majority of original works that have some spark of creativity to them. And so, independent creation is really the hallmark there. Just because two works are highly similar to one another, if they were actually created independently of one another without copying, without any knowledge of one author by the other, then those works actually do not infringe one another. So what does a copyright protect? Copyrights protect the owner's exclusive right to reproduce, distribute, perform, display, license, and prepare derivative works based on the underlying copyrighted work. It doesn't merely protect against copying, it protects broadly against a lot of different kinds of exploitations. Exactly how those rights apply to different forms of creative works, differs a little bit, but broadly speaking, copyright is going to protect phonorecords, which are the physical manifestations of sound recordings. They're going to protect literary, musical, dramatical, and choreographic works. Copyright protects motion pictures and other audiovisual works, whether that's a television show or a YouTube video. Copyright will protect any format where moving pictures are attached to sound or not attached to sound. Finally, copyright is also going to protect things like pictorial, graphic, architectural, and sculptural works. If it's able to be fixed in a medium of expression, then it's capable of protection. So if something is not fixed in a tangible medium of expression, for example, an impromptu speech that's not recorded in any way, is not written down, that's actually not subject to copyright protection because it's not fixed. So idea versus expression, kind of a cornerstone of copyright is that copyright protects a particular expression. It doesn't protect the underlying idea. So, the example here, Olympus Has Fallen versus White House Down. If you have two movies, both with the idea of a president under siege and doing battle with bad guys, that idea is not protectable. But of course, the particular expression in a particular screenplay or a particular motion picture will be. And so when you have copyright battles between a motion picture producer and someone that has a screenplay that they claim was infringed, oftentimes it requires a court to go through and identify the particular unique aspects of the plaintiff's work to see what of those aspects were actually taken, or are the commonalities just things that are common to a particular type of movie or a particular genre. If it falls into the latter category, then the defendant's going to win. If the plaintiff can prove that that a lot of very unique things about that original work were taken and that the defendant had access, then there's a plausible case there. And that kind of gets to the idea of the whole of having particular sorts of conventions in a genre, whether it's a genre of motion pictures, of music, of novels. If there are certain characteristics that the vast majority of works, or even just a good number of works in a particular genre are going to have, then those are considered fair game for everyone to use. And if someone is going to maintain a copyright infringement suit, they need to show more than just the commonality of those elements that everyone uses. So who owns a copyright? Generally speaking, the author is the one who owns the copyright. So if it's a book, it's going to be the author of the book. If it's a photograph, it's going to be the photographer, not the subject, because the subject is not fixing the photograph in a tangible medium of expression. It's the photographer. If it's a sculptor, it's going to be a sculptor. The exception that often comes about is work made for hire. In a work made for hire situation, the owner of the copyright is the employer or the person who commissions the work. So if it's an employer, the employee must have created the work in the scope of his or her employment. It has to be part of their job description to create, a particular kind of work. If I work for the HR department of a company and I prepare an employee handbook, and that's part of my job, the copyright in that employee handbook is going to belong to the company. I can also agree in my employment contract to that the works that I create in the scope of my employment are going to belong to the employer. This can be complicated if the person actually isn't an employee. And whether someone is an employee or an independent contractor can be, sometimes complicated question of state law, going to, how much control the company has over the person and what their responsibilities are. If the person is not an employee and is instead an independent contractor, then in order for something to be a work made for hire by contract, it needs to fall within 9 statutory categories that are eligible for a work for hire designation. If it falls outside of those 9 categories, it doesn't really matter what the company and the person put down on paper. that is not going to be an effective work made for hire provision. If that's the case, and work made for hire is not an option between a particular person and the company, then you need to have a written assignment in order to affect that transfer from the contractor to the company. So in order to have an assignment has to be in writing. A copyright assignment that is not in writing has no effect. And so when you're using copyrighted material from another source, you should always seek permission from the copyright owner to use the material, and you should get that right in writing, whether it's a license or an assignment. And that can be, if it's exclusive and if it's permanent, then that's an assignment. If it's only for a limited period of time, or if it's non-exclusive, then it can be a license. There are all kinds of different rules that are going to be beyond the scope of this presentation for particular kinds of licenses for particular kinds of work. Music has its own set of rules, both for compositions and for the licensing of sound recordings. There's an entire licensing process for literary works. But as a broad general rule, if you're going to be using the content of someone else in your advertising, on your website, really in any manner, you should obtain a license. And if you can't figure out who you need to get the license from or how you go about doing that, talk to your counsel, and your counsel can guide you through the process and find the right people. Copyright infringement, similar to trademark, has its own set of remedies. If your copyrighted works are being used by someone online, there are takedown processes through social media sites, through online marketplaces. If you're talking about forums like YouTube, there's the Digital Millennium Copyright Act, which has a process through which a content owner can file a complaint, and there's a process that the service providers use to take down infringing works. Now, if those works go back up, there's a process through which the infringing party can contest the takedown. In practice, that rarely happens, and it can be an effective process if the online infringement is not too widespread. If in the music context, for example, because infringing works can pop up so often, there's a big debate over whether the DMCA is effective at protecting content holders' rights, or whether it's too burdensome and ends up being ineffectual. In any event, as with trademark, copyright also carries with it potential monetary awards. It's possible to seek actual damages. In other words, the ill-gotten profits of the defendant, or the lost revenue of the plaintiff. If the work is registered before the infringement occurred, it's also possible to seek statutory damages and attorney's fees. And as with trademark, it's also possible to seek an injunction, either on a permanent or a temporary basis while the litigation is going on. A few minutes on fair use. Fair use is a defense to trademark infringement. It's one of the most complicated areas of copyright law. I've done 3-hour talks just on fair use and providing an analysis of these factors. When assessing whether to rely on fair use in using the copyrighted work of someone else, keep in mind that it's a defense. If you're using the work of another, you would basically be relying on a court finding in your favor that the Section 107 factors permit your use. There are a limited number of areas where it's so clear that as a matter of course, people are willing to for example provide short excerpts of a literary work in a review of that work. That's it's such a textbook example of fair use that people are willing to do that. But most of the time when people are considering fair use, it can be a close call, and the predictability of these decisions in court can be quite challenging and nuanced. And just kind of briefly to go through the 4 factors that a court would consider in assessing whether use of a copyrighted work falls within fair use. First, the court is going to consider the purpose and character of the use. Is it a use that's being done for educational purposes, for charitable purposes, or is it being done in connection with a for-profit enterprise? In connection with the purpose and character of the use, the court is also going to consider whether the defendant's use of the work really transforms the meaning of the plaintiff's work. So, for example, if you're using it to parody the original work, that can be considered transformative and privileged under fair use. Second factor is the nature of the copyrighted work. Works that have a great deal of creativity, such as music or motion picture, are going to be given broad protection, and so it's harder to argue for fair use compared to works that are more based in fact, or things like databases, which are given a more narrow scope of protection. The amount and substantiality of the portion used. Basically, the more you take of another's work, the harder it is to claim fair use. And this analysis is both of the overall amount taken, a quantitative analysis, and it's also the quantity or the quality of that taken. So if you're taking kind of a very small amount of a musical composition, but you're taking the heart of it, that everyone's going to recognize, that can weigh against you, even though the amount in a quantitative point of view is very small. If it's the key, riff from a song that everyone recognizes, that can weigh against you. Finally, maybe the most important factor is the effect of the use on the potential market for the copyrighted work, for the original work. If you're damaging the value of the original work, it's going to be hard to argue for fair use. So oftentimes clients will ask, whether a particular use of another party's mark or another party's copyrighted work in advertising is permitted. Generally speaking, fair use in advertising is extremely rare because it's for a for-profit nature, and because there's a robust availability for licenses. you're rarely going to succeed with a fair use argument if you're using the work of another in your advertisements. Another question that often comes up is whether you can use the work, although, with a disclaimer that, you didn't have permission or that it's the property of the author. Generally, disclaimers are going to be ineffective in advertisements. The kind of general advice is if you're talking about use of another's creative content or another's trademark, acquire a license, get permission before you use it in advertising. So there's also a fair use test when it comes to use of a third-party trademark. It's unrelated to the copyright fair use defense or fair use test, because the purpose of a trademark is different, and it's subject to different rules. So there are two kinds of fair use when it comes to a trademark. The first kind of use is classic fair use, and that happens where a third party has a descriptive trademark, and you are not using the term to refer to that party's product or even as a trademark, but you're just using it to describe your product or service in a way that is just the ordinary usage of those words. So if there were a trademark for ultra clean car wash, and you put out an advertisement in the newspaper, come to my car wash and your car will get ultra clean, and then you come to find out that there's an ultra clean car wash trademark registration out there. Potentially you would have a classic fair use defense, so long as the facts didn't indicate that you were trying to trade off of that name. If you were just using those words in an ordinary descriptive way, you would have a plausible defense. The other kind of fair use for a trademark that's possible is nominative fair use, where you're actually truly referring to the trademark of another in an accurate and correct way. So if you're engaged in competitive advertising and you call the other party's product by its name, and you otherwise are following all of the other rules concerning competitive advertising, it's perfectly permissible to use the trademark of another in that way. Now, you can't use it any more than is necessary to make the comparison. You shouldn't be burying the word 100 times in invisible text on the website in order to generate additional hits. But for that purpose, to make the comparison, it's appropriate to take advantage of the nominative fair use doctrine. So let's move on to the right of publicity. The right of publicity is the doctrine of law that relates to the ability of a person to control his or her identity for commercial purposes. And I'm going to be kind of referring mostly to Illinois law in my brief discussion here, because I am in Illinois, I'm an Illinois lawyer. But different states have their own right of publicity statutes or common law that protects the same thing. In talking about the coverage of the right of publicity, it's going to cover not just someone's name, but also their signature, their photograph, their image, their likeness, their voice, or even copies of these things. So there have been cases where actors have been used to imitate famous people and to replicate their persona, and that kind of conduct has been held to violate the right of publicity, even though it wasn't the actual image of the person whose rights were being infringed. There are there are exceptions for artistic works. If you're, writing a biography of a famous person, and that biography isn't a commercial advertisement, it's just, a standalone product or a biopic or something like that. That's going to be exempt from a right of publicity claim. There are also exemptions for non-commercial purposes, such as news reporting, where nothing is being sold, rather, the person is just being talked about in a newsworthy way. And, if you're talking about, an artist or an author, it's always permissible to, accurately state that they were the author or creator of a particular work. And like I said, each state, the text is really small behind me, but each state has its own rules concerning how long the right of publicity lasts. In some states like New York, the right of publicity ends upon a person's death. In other states, it survives death. Here in Illinois, it's the life of the person plus 50 years under certain circumstances. A right of publicity can be assigned or licensed. It can't be licensed for longer than the term. So in New York, for example, a person cannot grant a license to the right of publicity after they die, because the right extinguishes upon their death. But here in Illinois, that would be possible. So how does the right of publicity differ from the right of privacy? Originally they came from the same body of law. Here in Illinois, we have three other kinds of privacy rights, which you should be aware of if you're considering using a person's identity or certain facts about them on your website or online. If you publicize someone by placing them in a false light, that can be actionable. And by false light, what the law talks about is something highly offensive to a reasonable person, where kind of you knew or acted with reckless disregard of the false light in which the plaintiff would be placed. The second kind of privacy action, which is available, is giving publicity to private facts. And so those would be, facts that would be highly offensive to a reasonable person and not of legitimate concern to the public. That can be actionable. And the third is intrusion upon seclusion. And that happens where there's been an unauthorized intrusion or prying into the plaintiff's seclusion in an offensive or objectionable sort of way. And something private has been disclosed as a result, and that's caused anguish and suffering to the victim. The right of privacy is somewhat limited, probably more limited than most people think. But if you are going to be kind of referring to a person's identity, either in a commercial way or in a way that is going to talk about, facts that are potentially offensive or objectionable, you should be aware of these statutory rights. So we're going to get to kind of a few practical considerations here. If you're putting together your advertising, your website, media for your company, when do you need a license? I would say, if you're using creative content, you should pretty much always get a license if you haven't authored those works yourself or through your employees. Whether that's, a literary work, using a photograph, graphics and visual art, music, audio visual. you know, the risk is too great in order to operate without a license. And in the advertising context, your fair use arguments are going to be limited at best. You can use works that are in the public domain. And so those are works that will not require licenses for their use because there's no longer any copyright. In other words, anyone can use it because they're no longer owned by anyone. Generally speaking, works made in or before 1924 are now in the public domain as of 2020. There are kind of different copyright statutes and rules concerning renewals that make the precise calculation of copyright term a case-by-case basis, particularly for older works. But generally speaking, when you're talking about works that are upwards of 100 years old, those works are starting to fall into the public domain. I would say if a work is on the cusp, I would do your due diligence before using it to make sure it's in the public domain. If you're talking about works that are dating back to the 19th century, you're generally in good shape. Abandoned trademarks, like copyrighted works that have fallen into the public domain, are not protectable. So a trademark that is no longer in use and where the registration has lapsed is considered no longer a protectable mark and potentially could be used. Be careful again to do your due diligence. There are some marks that you would think have fallen into the public domain because the brands are no longer in the public eye as they once were. But if the mark owner makes even a limited use in order to maintain rights or maintain the registrations, you could wind up in trouble, thinking that a mark has been abandoned when in fact it's not. Creative Commons is one avenue through which media and advertising, will often kind of seek to, gain access to content. You need to be careful to read the fine print of the licenses. There are often limitations to only use the works for non-commercial purposes. If you're going to rely on, one of these blanket licenses, make sure that the use that you seek falls within the license, because Creative Commons does not mean public domain. There are limitations attached, whether it's for non-commercial purposes, whether it requires credit be given. You need to make sure you're in compliance with the terms of the license in order for that to be a good solution for you. It's also important to keep in mind that the right of publicity and the right of privacy are separate from copyright and trademark laws. If you get a license from a local celebrity to appear in your television advertisement, you could very well film them and have them appear in your advertisements. But then if you use a photograph of that person to put on your website, you could run afoul of copyright if you don't clear rights in that photograph. Just because you obtain a license with regard to a right of publicity or right of privacy doesn't mean that you have the right to use photographs or videos of that person if the content, the copyright in the content is owned by someone else. Considerations for retaining an independent contractor to help develop your website or advertisements. Oftentimes the expertise for developing content will lie outside of your company. So you'll hire someone to either put together your website or develop your advertisements. the contractor should warrant to you that the elements that are being created are original and aren't going to infringe anyone else's rights. And also, if you're hiring someone to create a new logo for you or a new brand, who is responsible for doing a clearance search on that mark? Is that the contractor's responsibility? Is that your responsibility once they come back to you with ideas? Your contract should always be clear about whose responsibility clearance is. If third-party content is going to be licensed in connection with the development of a website, whose responsibility is it to obtain and pay for those licenses? That all should be in your contract. Similarly, if there's a breach of any of those provisions and you are sued, what's the contractor's liability? Will it provide indemnification? Will it be able to bear the expense of defending against a lawsuit, even if it does provide indemnification? Those are all very important terms that you should carefully consider when entering into a contract in connection with the development of any of these products. Specific issues related to advertising. This presentation hasn't been geared toward advertising generally, rather IP issues in advertising. But broadly speaking, stay away from making misleading claims. If you're referring to a competitor's product or service, don't do so in a disparaging or misleading way. Don't make any false suggestion of connection, association, or endorsement with another person or another company. All of these things can get you into trouble. Don't go on to social media or product review sites under false identifications or false pretenses to make complaints about competitors. That's likely to be anti-competitive behavior and get you into trouble. And finally, be aware of your company's insurance policy and what advertising issues are covered and what issues are not covered. Another practical issue involves employee policies and procedures. It's important to include if that employee has any responsibility for creating or developing potentially copyrightable or patentable work, that there be work made for hire provisions in the agreement, along with assignment language, just in case that employee were ever found to be an independent contractor rather than an employee. It's better to have a belt and suspenders approach. Other terms that you should consider including are provisions that provide for the return of company materials upon conclusion of the employee's term of employment, training regarding third-party copyrighted materials and trademarks. In other words, providing them with kind of the overarching recommendations that have been made in this presentation about what you should do if you want to use the third-party copyrighted materials or trademarks of other companies, and similarly, what to do if your company's materials or marks are used by others. Finally, what the expectations are concerning reliance on fair use and advertising review to make sure that the company policies on these issues filter down to the employees. And I'd like to just thank you for joining in and watching the presentation today. If you have any follow-up questions, my contact information is right behind me. I'm James Griffith. I'm with Ziliak Law. My contact details are right above my shoulder, and I'd be happy to answer any questions that you have regarding anything in the presentation today. Thank you.